your client, your attorney asked you how much you make per month. Is that right?
My name is Mr. Jackson.
Yes, Mr. Jackson. You were asked how much you make per month. Is that right?
That's my salary.
Okay. And what is your monthly salary, gross?
I don't have the numbers in front of me, but it's what I said, around, it's about $960 something pay period, which ends up being about $1,800 a month, roughly, gross.
All right. And you are employed as a bus driver for the Atlanta Public School. Is that right?
Correct.
And you've been employed there since August of last year, correct?
It's 2022, that's correct.
Okay. And you were employed August, September, October, November, and December. That's 5 months, correct? Is that right?
Yes.
And so if we are to believe your testimony and we multiply $1,800 per month times 5 months, you would have made $9,000 last year from August until December, correct?
That's not correct, ma'am.
Okay, then how much did you make from August to December?
You didn't ask me how much I made from August to December. I don't know. I answered what my salary was.
Okay, so you do not know how much you made from August to December.
I don't have the numbers in front of me, but I've submitted my W-2s.
Yes, perhaps, Judge, if I may be allowed to share the screen so we can refresh Mr. Jackson's recollection.
We will have to temporarily make you a co-host.
Okay.
Can we do that, Ms. Goodman? Or Ms. Broom? Hold on, Ms. Goodman might be on the phone.
And Judge, I just have 3 more questions, and this is very relevant. A, to his ability to pay for supervised visitation, his credibility, and number 3, my request for attorney's fees at the end of this hearing, Your Honor.
Okay. And while we're on that, since while we're waiting, Ms. McLaws, so your motion did say he wasn't able to pay anything and just wants unsupervised. But you have asserted that he may be open to paying for supervised at a different location?
Yes, Your Honor, because he would like to see the children.
Okay.
He would like to have the opportunity to see them.
Okay.
So, I mean, he has limited funds, but you heard him say he'll do what he needs to do to be able to have a relationship.
All right. I just want to, have you looked into any locations and have any that you are recommend? I mean, I'm not saying I'm not there yet, but I'm just, do y'all, I have any recommendations to the court of places that can do that? Because there has not been anything like that put before the court at this point.
I have a couple of calls in, Your Honor. I did think about that. Some places closer to both of them, maybe in Fulton County. I was waiting to hear back from a friend of mine who does a lot of practice in Fulton on this issue, just to find someone that is reasonable. The one organization I had heard of, I heard they've closed down. So I hate to say that, but I'm working on that. I know that's not a great answer, but that's what I got.
Okay. All right. Well, I just wanted to have an idea.
Sure.
Because that's a little bit different than what was requested. And so I wanted.
Yeah, sure.
All right. Ms. Goodman, are you there? And can you please make Ms. Koski a co-host?
Yes.
Thank you.
Was it something on the exhibit? My screen blanked out.
Oh yeah, Ms. Broom, is it something, Ms. Koski, that you have submitted and attached, or is it something? No, it's not, and I don't think it's and actually,
I see that A, B, and C, but
No, Judge, this is being used for the purpose of impeachment.
Okay, so it's just an
Oh, okay.
impeachment. It's not an actual. So I will, if she could share, I think, has she been made?
Yes, she is co-host now.
Okay.
It should be at the bottom of the screen.
Thank you.
All right, Mr. Jackson, can you see my screen?
Yes.
Okay, so if your testimony to this court was in fact true, and you only made $1,800 from August to December, why would the W-2 your own attorney provided show $18,144.36?
Ma'am, you're playing with words. I never said what my salary was from August to December. I said I didn't know. I stated what my salary was with APS.
Okay, so you would agree with me that if we divide 18,144 by 5 months, your gross income is $3,628 just for last year in 5 months. Would that be a true statement?
No, I wouldn't agree with you, ma'am, if you're asking what my salary is. Now, I made more money than my salary was because I worked an insane amount of overtime.
Okay, let's hold on one second. I'm sorry to interrupt, but I want to take this down since there are social security numbers on this. I don't want it to be broadcast.
Judge, they're redacted. They're redacted.
Oh, all of them are?
Yes, Your Honor. Yes.
Okay, so good. Sorry. Okay, thank you. I couldn't see it first on there. All right.
Yes.
Okay, go ahead. All right. So you may continue your explanation, sir.
And also, she also has, Attorney Kosky, has a letter from my employee that states what my income is and states that overtime isn't guaranteed. She has all that information, so she can pull that document up as well. That proves what I answered was what my salary is. She never asked me how much, when she asked me how much I made from August to December, I simply said, I did not know. I answered what my salary was.
All right. And so let's
I did
move now.
work the same amount of overtime because paying for attorneys is costly. I don't have my children at home. And to be quite honest, working became therapy for me. So I worked as much as I could to earn as much money as I could to fight for my children, to pay for all these attorney's fees, and to have something to do other than go home to an empty, childless home.
All right, Mr. Jackson. And then if we move on to your gross income for this year alone, you have made a total of $27,966.76. Very much contrary, sir, to your testimony that you make $1,800 a month. Is that not right?
That's not right. First of all, I don't know what those numbers you're referencing are. I simply answer what my salary is, ma'am. And like I said, you can pull up the document that you've also been tendered where my employer told you what my salary is and told you that the only thing that's guaranteed is my bi-monthly salary of, I know annually it's about, well, anyway, I know it's about $1,900 a month. All that's in writing, all that's been documented, it's been notarized. You know what my salary is from my employer. And that's what I answered, what my salary.
Mr. Jackson, if we divide $27,000 by 6 months, that would be gross $4,500. All the meanwhile, you're accruing $22,000 in black child support. Is that not right?
Objection, Your Honor. Relevance, if we're going to go into the Fulton County contempt, she objected to that as not being relevant. None of this is relevant.
All right. Did you withdraw the question?
I did, Your Honor.
Okay, thank you. We're not going too much into finances for this case because that's going to be resolved in Fulton County. All right, anything else, Ms. Kosky?
Nothing further, Judge.
All right, anything else for this witness, Ms. McLaws?
No, Your Honor.
Okay, all right. Any other witnesses for the respondent?
Yes, Your Honor, I'll call Mrs. Brown for the purpose of cross-examination.
All right, Ms. Brown, you may call her and I would ask you to swear her in as well.
Yes, Your Honor. Ms. Brown, will you please raise your hand so your right hand so everyone can see you? Thank you. Do you swear and affirm the testimony you're about to give before this court's the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I swear.
Thank you. It is true, isn't it, that the minor children are currently in therapy, correct?
Just one of her daughters, correct.
Just one of your daughters. Did you provide the therapist with a copy of the TPO order?
Yes,
And you have also provided the school system with a copy of the TPO order, correct?
correct.
And initially, the court had ordered that Mr. Jackson's visitation would begin within 14 days, correct?
I believe we had to take some classes and then begin the visitations.
Okay. And you didn't actually take the orientation within those 14 days, did you?
I believe I did.
Okay. And your children, your daughters, your oldest is in school, correct?
Correct.
And she's had some behavioral issues at school, isn't that correct?
No.
No, not at all.
Behavior issues?
Yes.
I'm not aware of that.
Okay. That's all I have, Your Honor.
All right. Any other witnesses, Ms. McClaus?
No, Your Honor.
All right. Ms. Koski, you may call and swear your first witness.
Judge, the only witness I would call is the Marilyn from Nia's Place, Your Honor.
All right. We will bring her in.
Bring her in now, Judge.
Thank you. And you may swear her in, Ms. Koski.
Of course, Judge. Good morning, ma'am. Can you please raise your right hand? Do you solemnly swear that the testimony you will provide today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Please tell the court your full name.
Marilyn Stenson.
And Ms. Spencer, how are you employed?
I am employed through the Women's Resource Center as Program Director for Nia's Place Supervised Visitation and Safe Exchange Center.
All right. And it is my understanding that you have, in essence, a contract with DeKalb County to provide supervised visitation for individuals who have TPOs, correct?
That is correct.
Okay. And how long have you been employed there?
24 years.
All right. Now, did you have an occasion to be assigned the case of Mr. Jackson and Miss Brown?
I have monitored 2 visits with that family.
Okay.
And more recently, I was present during an incident that required suspension.
All right. Before I get to the incident and what, if anything, you observed during the supervised parenting time, when a case is referred to you, the parties have to go through orientation, correct?
Correct.
And in the orientation, they have to go to a class and they sign certain documents that outline the guidelines for participation at Nia's Place, correct?
That is correct.
And I'm going to move this along. I'm sure if there's an objection overleading, I will change my questions, but I want to move this along. Part of the guidelines require the parents not to remove clothing or anything of the child's appearance, correct?
That is correct.
And that includes earrings, yes?
If that changes the appearance of a child between the process, yes, that would include jewelry.
And another guideline that you have in place is that parents speak only in English to the minor children, correct?
That is correct. And during the orientation phase, if a parent wishes to speak in another language, it would require an interpreter. And that opportunity is given to each client during the orientation phase.
And you would agree with me that that's also for the safety of everyone involved, correct?
Absolutely.
All right. Now, are you aware whether or not Mr. Jackson actually participated in orientation and was provided with the guidelines that we have just discussed?
He did complete an orientation and signed the agreement and was given a parent guide to take with him.
Okay. And in the agreement that he signed, all of these rules would have been outlined, correct?
Correct.
Okay. And then Mr. Jackson started supervised visitation with his children, correct?
That is correct.
Now, based on your knowledge, was there ever a delay or any sort of situation where Mr. Jackson, for any reason, give it Nia's Place, Mrs. Brown, anybody, was prevented from exercising continuous parenting time with his children?
Never. Actually, the stipulations were every other Sunday, 3 p.m., and every other Tuesday, 5 p.m. But Mr. Jackson requested that they be held every Tuesday instead, and we accommodated that
Without any issue from Nia's Place?
without any issue. If we had availability and we provided that.
All right. And there is no cost for using Nia's Place, correct?
No cost whatsoever.
Okay. All right. During, and if you can, please, could you itemize to the court, if you can recall, or if you need to refresh your recollection, what days did Mr. Jackson exercise visitation?
Mr. Jackson exercised visitation on 11/27/22, 11/29/22, 12/11/22, 12/13/22, 12/20/22, 12/27/22, January 3rd, 23, and the final visit was 1/10/23.
All right. And during, I think it's 8 visits total,
Correct.
were there any reports to you or to any supervisor regarding behavioral problems with the children?
Objection, Your Honor, calls for hearsay.
Ms. Koski?
I do not believe that calls from hearsay. I asked a specific question. During her supervision or during the time anybody else supervised, was there any notation of behavioral changes for the minor children? This is the custodian of these records. She is the director of Nia's Place. She can testify to this information.
It's complete hearsay, Your Honor. Anything she observed, sure. I don't think that I would have objected, but anybody else reporting to her that they're not here, whether or not she's the custodian, that actually hasn't been established. But those individuals would need to testify. It's complete hearsay.
Okay, I'm gonna sustain it as to reports to her, unless the foundation can be laid later as to anything she's relying on, et cetera, and can revisit it at that time. But I'm gonna sustain it for now, and just as to if she is personally aware, she, you can ask that question.
And I'm going to break it up into 2 series then. Ma'am, the 2 instances in which you personally observed and supervised visitation, did you observe any change in behavior of the children?
I did not.
Okay. Did you observe any trauma by the children, any stress or anxiety presented by the children resulting from the supervision of this parenting time?
Your Honor, I'm going to object to this line of questioning for on several grounds. One, I don't believe she's been tendered or submitted as an expert witness. She's not a psychologist. She's not a psychiatrist. She's not a mental health professional. She hasn't been qualified. And I think some of that questioning about trauma would require an expert witness response. Additionally, Your Honor, I would object to the question as it's a very compound question.
Okay, so it's already been put before the court that there was an excited utterance mentioned when one of the child came into the room. So I think how the children's demeanor was and appeared that she personally observed, I'm going to overrule the objection to that, as she can testify to that. As to, she certainly, how they appeared is what I'm going to limit it at. As to whether they're traumatized, I will sustain the objection as to that, as it was asked in the question.
Thank
you. And ma'am, based on the judge's ruling, you can answer your question as to what, if anything, you observed from the children in the 2 times that you supervised the visitation with Mr. Jackson?
Okay, we see quite a bit of children every week. Some resist. We don't force any children that resist to attend the visitation. Neither child ever resisted it in my presence.
Based on your observations, did they appear to be having a good time with their dad? Did they engage properly with their dad?
During my observation, the visits went well.
All right. Now, I asked you what your job at Nia's place is. Why don't you go ahead and elaborate a little bit about that?
Okay, so I am the program coordinator. I supervise actually 6 contractors. We provide supervised visits. That's an in-room monitor at all times. Children are never left alone with the other parent. In addition to that, we monitor the exchange of children by and between parents of the same child.
All right. And in your role in supervising your 6 other contract employees, they report directly to you. Is that right?
That is correct.
And they are required to make reports if there are any incidents on any of the supervised visitations, correct?
That is correct.
And that report would come directly to you.
Yes, for my signature.
And as a director, you would safekeep all of these reports in each of these children's files, correct?
Correct.
So I circle back around to my question. Did you at all, on the other visits you did not supervise, receive any report regarding problems with the supervision?
Objection, Your Honor, that calls for hearsay. Unless the individual who wrote the report and who was present, she said she wasn't present for any of these other sessions. Unless they're present to testify, it's complete hearsay.
Koski?
I completely disagree, Judge. I've laid a foundation that this individual is the custodian of records. She supervises all contract supervisors that do the parenting time. And if she has personal knowledge as to the contents of the records that she maintains, she can testify to the existence of any report or not.
There isn't. What Ms. Koski's failing to understand is, as a custodian of the records, she can lay the foundation that she's the custodian, but that doesn't mean that double and triple hearsay contained in documents are automatically then admissible. The evidence code still provides that whoever wrote that report, whatever they are saying, is an out-of-court statement being offered for the truth. That witness needs to come in and testify. Otherwise, it's complete hearsay.
And Judge, I am simply—
And it could be triple hearsay, for all I know.
I am not asking about contents of anything. All I am asking is whether or not she received a report regarding any problems with visitation she did not supervise. The answer is yes or no. Based on that answer, then there may be problems.
Okay, I'll let her. So I'm going to sustain it as to the contents until we get to a point where it's something she was involved in, she may have signed. You know, we're not there yet. But I'm going to allow her to say if she received any reports, not what the contents of the reports were.
Thank you, Your Honor.
And ma'am, I'm going to ask the question again. Outside the 2 visits that you supervised, were there ever any reports received by you regarding any problems with visitation by Mr. Jackson and his children?
Yes, and for the record, I was present on the day of the most recent suspension.
Right. And so, and I want to divide those because I think that you testified that you had 2 supervised visits that you yourself supervised, correct?
Right.
And we can talk about those, and we will in just a minute. But out of the other visits that you did not supervise, you, as the supervisor and director of Nia's place, did you happen to receive any reports of problems with Mr. Jackson's visitation?
Objection.
Yes.
It's been asked and answered, and it's complete hearsay. She is trying to backdoor what the witnesses who aren't here and subject to cross-examination said.
Ms. Koski?
I don't believe that that's what I am trying to do, Judge, and I think you've made a ruling on that. If she says yes, then I have to lay a proper foundation for whatever it is that she, as the custodian of these records, is going to testify to.
So I'm going to overrule the objection as to whether she received any reports. I'm going to let her answer that question at this time.
All right. So on the occasions where you were not a supervisor, did you receive any reports of misconduct or problems with Mr. Jackson's visitation?
Your Honor, I'm going to object
Oh,
because,
Lord have mercy.
Your Honor, that is a completely unprofessional and inappropriate.
All right,
behavior.
let's not have, okay, we've had some back and forth. I've heard a little bit from both sides. Look, a letter was written to the court that he was terminated.
Right.
And he's
Yes.
testified that there was an incident. So I'm going to let her say whether she received reports as a function of her job. Because some of this is going to lead to an explanation about why things were done. And there may be some hearsay, and I will address it when we get to it. But I'm going to allow her to testify whether she received reports regarding any of the visits and whether she acted on them.
Thank you, Your Honor.
Ma'am, can you, I think you've answered the question. Let's please talk about the two incidents that you supervised. Can you tell the court when those occurred?
Give me just a minute.
Yes, ma'am.
I'm sorry, 11/29, 1/3/23.
All right. Let's talk about the first incident. Were there any issues or concerns with Mr. Jackson's supervised visitation?
No, there were no.
All right. Let's talk about the next incident, the January incident. Were there any issues or concerns with that visitation?
No, there were not.
Okay. All right. So now let's talk about other supervised visitation issues that could have happened. All right. To your knowledge, do you have any specific dates where there were problems with Mr. Jackson's visitation?
January 10th, 2023.
All right. And how did you come to learn about that information?
Following the visitation, I was presented with a concern from one of the contractors that jewelry was removed.
Objection, Your Honor, to the extent anything after I was presented with a concern. Anything else after that is going to be hearsay by a witness who is not present in court, and it is being offered for the truth of the matter asserted.
Ms. Koski?
I don't believe that that's hearsay, Judge. She's not saying what anybody told
Well,
her.
she was about to say, so she said she was presented but with a concern. So I'm going to have you stop there and then ask her if she acted on that.
Did you act on, and as a director of Nia's Place, what, if anything, did you do with the concern that was presented to you?
Before the visit ended and before Mr. James could leave prior to his wait time, I approached him and asked if he had earrings that belonged to the children. He walked out of the bathroom prior to that, and I asked him if he could give me the earrings. He said they're not supposed to be having them in their ears, and I do not have them. I asked him again. He said, they must have fallen out. Check in the room. And I had staff to check the room as well as the wastebasket. We did not find earrings. So I presented the children to the custodial parent who was concerned that the earrings had been removed. I explained to her the wait time and that I wanted to make sure she was in transportation and that we could have that conversation at a later date. I did refer to her that if they were not returned, we would subsequently suspend any further visits.
All right. And did you, were the earrings ever returned with your procedure, with Nia's Place procedure?
Was he cooperative?
Was he cooperative with you?
He did not present any jewelry.
All right. And after that, what, if anything, did you do regarding continued visitations with Mr. Jackson?
I submitted an email and a letter addressed to Mr. Jackson that we would be suspending all further visits. In addition to that, the court was notified of the suspension, which is protocol when there has been a violation.
And is this the only incident that you considered in making your decision to suspend visitation?
Absolutely.
All right. Have there been any efforts to restart the visitation or perhaps to rehabilitate the relationship with Nia's Place?
No, and he was informed in his letter that he was prohibited from making any contact coming to the property without concern because of situations that have occurred. But we made it known that we did not want him to call or to come back to the property, which is typical after suspension.
All right. I have nothing further for this witness, Your Honor.
All right, Ms. McLaws, you may cross-examine.
Thank you, Your Honor. The question was posed to you, did Mr. Jackson make any efforts? You are aware that I called Nia's Place and I believe I left a message for you asking someone to call me back to see if the relationship could be repaired. Are you aware of that?
I am not aware of that.
Okay. And if Mr. Jackson had returned the earrings or handed them over, the suspension would not have occurred. Is that what I heard you say?
If he had returned the earrings, we would have had some conversation,
All right.
but it would definitely have not ended as a result of that. We're at liberty to perhaps suspend for a couple of weeks because it's important that our clients help to create a safe space.
Okay.
In doing so, that's acknowledging any efforts by a contractor, staff, child, parent. We all create that space.
So if the court, now that, well, let me ask you this. You said that Mr. Jackson was provided with the policy of Nia's Place, correct?
That is correct.
And where in the policy does it specifically refer to jewelry that the children are wearing?
It doesn't specifically say jewelry.
And if Mr. Jackson were to agree from this point on, he won't remove jewelry, he won't do anything, would Nia's Place consider allowing him to resume visitation until this order expires in October?
No, we would not.
Okay. Do you happen to know, because I'm sure you work in the community and you know lots of folks, who you might refer Mr. Jackson or make a suggestion to the court as to who might be an appropriate supervisor for Mr. Jackson and the children?
I can't make a referral to who would be a perfect supervisor, but I could direct you to the Supervised Visitation Network.
Okay.
Which may help to achieve, what is needed.
All right.
They can provide different centers that are in the area.
Wonderful. And this Supervised Network, how would we locate that information?
Supervised Visitation Network.
Okay.
On the website.
Thank you so much.
Absolutely.
And then let me ask you one question. On the 2 visits that you observed Mr. Jackson and the children, did they appear afraid of him at all to you?
No.
Did they appear that they had a loving bond with their father?
Yes.
Thank you. I have nothing further.
Mhm.
Ms. Kosky, do you have any redirect?
None at all, Judge.
Ms. Stenson, I have one question. When you say he said they must have fallen out, what exactly did he say to you?
He said, they shouldn't have them in their ears when I asked him to give me the earrings. And he said, I don't have them. They must have fallen out
Of the ears or the pocket? What was,
of his pocket.
okay.
Mhm.
All right,
Meanwhile, he was returning from the restroom by the time I got there.
okay. Did you ever find the earrings in the restroom or anywhere else in the location?
Not at all.
Okay.
We've searched continuously in that one room, which is very small, and there were no earrings.
Okay. And based on it now being, I guess, several months from then, y'all are not open to him re-enrolling and restarting visitation with y'all?
No.
Okay. All right. Well, thank you, ma'am. Do y'all have any more questions for her?
Not on our behalf.
No,
All
Your
right.
Honor.
Thank you, ma'am. You are.
Thank you. All right, thank you.
All right, Ms. Kosky, any other witnesses?
None, Judge.
Okay. All right, I will hear brief argument from both sides. Ms. McClaws, do you want to waive opening and just close?
Yes, Your Honor.
Okay, I will hear from you, Ms. Kosky.
Yes, Your Honor. I have been practicing law 16 years, Your Honor, and there are things that I do not do lightly. And in this situation, I pondered over my response because I was outraged at the number of untruths being presented, particularly number 6 and number 7. Number 1 is that Mr. Jackson, in his petition that he filed through his attorney, told this court that he needs normalized parenting time, and that in essence, his parenting time has been prevented by Nia's Place, which is an incredibly reputable organization that the court uses. And then paragraph number 7 states that he just can't pay for the supervised visitations, which is entirely untrue. And it is troublesome for me to believe that a licensed attorney, a licensed practicing attorney would make these false allegations to the court in a written pleading. Once my answer was received, I am baffled that there was no amendment to correct these untruths, and that quite frankly is concerning. But more concerning today is the number of untruths that we have heard. I first will talk about what the standard is in order for you to modify visitation. There has to be a change in circumstances which would persuade Your Honor to remove either the supervision or to change the supervision or anything of that nature. Mr. Jackson testified that his children are going to therapy because of this, that there's been behavioral issues, that there's been educational repercussions, none which have been proven, none which were corroborated by Mrs. Brown, none which were corroborated by Nia's Place at all. And I proffer to the court that Mr. Jackson no custody has been taken away from him. He has full access to educational records. He has full access to medical records. He has full access to therapist records. So if he would have met his burden, he would have presented himself with documentary evidence to show all of how these children's well-being has been affected by the supervised visitation. So then I move on to his testimony as to how his children have been, I think what the word he used is traumatized by the supervised visitation. This couldn't have been farther from the truth from your independent witness, our independent witness from Nia's Place, who didn't see that. Said that this was a loving relationship, that the children love him, and that they got along well with Mr. Jackson. The problem Mr. Jackson has, that it is his behavior that has landed him with the issuance of a TPO by this court because of his violent behavior to somebody else. And it is his own conduct that has resulted in the termination of his supervised visitation. Now, Mr. Jackson tried to tell you that he didn't know that there was any rules about altering somebody's attire or presence. He also told you that he didn't know that he couldn't speak to his children in Spanish. all which was contradicted by Nia's Place director, who testified that he was given an orientation, that he was given the rules, and that he signed them. He then also told you that his parenting time had been obstructed by the mom. When Nia's Place was asked about whether or not any problems by Mrs. Brown had been presented in exercising parenting time, the answer was no. In fact, she testified that she accommodated Mr. Jackson, and there were no problems accommodating Mr. Jackson until such time as his visitation was suspended because of his own actions. Judge, I don't believe there's any merit to this motion. I think this motion is frivolous. I think this motion is filled with a bunch of untruths, statements, both by an attorney, which is troubling to me, and by Mr. Jackson. You couldn't even get Mr. Jackson to tell you how much he earned. That's how much he lies. I believe that supervision needs to be continued. My client has no issue with it, but Mr. Jackson didn't come with the tools today to say, Your Honor, I had a problem with Nia's Place. Here are my options. In fact, it was Ms. McLaws who, in cross-examination of Nia's Place's director, made an inquiry. They've done nothing. January to June, 0 efforts to sort of get back on track. We would ask that the motion be denied. We would also ask for an award of attorney's fees pursuant to 1913-4, subsection 10 and 915-14. I will be heard at whatever time it is appropriate for me to be heard on my request for attorney's fees. I have prepared a detailed invoice to that effect that has been presented to Ms. McLaws, and I would like to be heard on that when the time is appropriate.
Well, I'll go ahead and tell you I'm going to reserve ruling today, so I will go ahead and hear from you on that now, just so we don't have to have any future hearings.
Yes, Judge, and I will share my screen.
We may need to make you co-host again.
No,
have you submitted this have you filed this or submitted this to the clerk's office for?
Your Honor, evidence is closed. I object to her being able to present any evidence. Evidence closed. We're in argument.
As to attorney fees?
Yes, Judge, she had.
Well, I'm going to let her reopen evidence as to attorney's fees, and you may cross-examine if you wish.
Thank you, Your Honor.
All right, Judge. First, let me go ahead and tell you that I have been practicing since 2007. I've been a proud member of the State Bar since that time. And 90% of my practice is family law exclusively. My hourly rate is $300 per hour, which is customary to a family law practitioner in Metro Atlanta area. I have been the only attorney assisting Mrs. Brown since in all of the cases Mr. Jackson has filed. I will now share my screen and submit to the court. Oh dear, I thought I had it open. Well, 1 second, Judge. All right, I have presented Mrs. McLaws with my invoice of attorney's fees. My attorney's fees in this matter is $1,814. Out of that, we have expert testimony fee for Nia's Place. They asked for $250 as a fee. So, and then there was postage fees of $10 spent to send Mrs. McLaws and Nia's Place copies of the subpoena via priority overnight mail. So those are costs associated, but my attorney's fees total is 5.18 hours. And I only billed, Your Honor, 1.5 hours for today's appearance, but I have been logged in since about 8:45, and it is now 12:30. I'm not asking for additional time because a lot of times we're waiting. And if you will look at my invoice, Judge, it is simply review and analyze the petition, draft the response, draft the pleadings to Nia's Place, email correspondence to Nia's Place to provide instructions for today, preparation for yesterday for the hearing to include testimony of my client and representation of my client in court. All of these items are specifically tailored to the defense of this action. And so I don't believe that any of them would be excluded. So my attorney's fees is $1,554 and the expenses is $260. Your Honor, under 1913(4) subsection 10, I am allowed to request attorney's fees in a TPO action, but I'm also allowed to request attorney's fees under 915(14). I believe that I could also request attorney's fees under the frivolous statute, in which Mrs. McLaws, in receiving our pleadings, in receiving the supporting documentation to our pleading, which completely contradict her allegations made in her petitions. And I forgot about the appeal. She also put it in that the case was under appeal, which is also untrue. She is the attorney that handled both of these actions, and together with the accompanying documentation. She should have withdrawn this action immediately upon receipt of my answer. So we would be asking for an award of attorney's fees of $1,800, and I think it's $54, and I'll email that to the court as an exhibit, Your Honor. The same are reasonable as well and tailored to this action, Your Honor.
All right, Ms. McLaws, do you want to cross-examine her as to attorney's fees?
Yes, I do, Your Honor.
Okay, go ahead.
Can you show the court where in your billing you billed to mail me a copy of the subpoena? Can you show me that where that was in your itemized billing?
I didn't charge for it because I don't think it's a charge that's proper for you to have to pay. And I believe in my pursuit of attorney's fees, that entry would have been excluded because it's not in furtherance of today's defense. So I didn't.
So you did not list a line item for mailing me the subpoena, correct?
No, I'm not going to bill my client for sending you correspondence. I will bill for the postage.
So the $10 that's reflected was sending me overnight mail.
Actually, in fact, I actually discounted that as well because the U.S. priority mail, let me pull up the receipt. That receipt is actually $7.50.
And that was sent to me.
Hold on a minute, please. It was $7. I don't have the receipt in my notebook, but it was $7.50 for both of the U.S. priority envelopes. And I actually, in fact, discounted that and didn't bill the entire amount. So I just billed a reduced rate of $10.
So it's your sworn testimony that you put into United States priority mail. Did you have tracking associated with that?
I do not believe that used tracking because I'm sending it to a lawyer's office. And the reason I sent it via USPS and not via email was because it also included a copy of our check that has sensitive information. And so putting it through the web, and if your emails are intercepted, then my bank account is intercepted and I don't want that headache.
All right. And how much money has Ms. Brown paid you?
She's paid me $0 in this case. No money.
And isn't it true that you have indicated in other legal proceedings that you represent Ms. Brown pro bono?
No, ma'am.
And you don't expect Mrs. Brown to pay you for your representation of her in this case, do you?
Yes, she has paid me at $250 every other week that she sells my account. And in fact, that is being used and applied to her oldest invoice, which is your frivolous appeal.
All right. So Mrs. Brown is paying you $250 every other week.
Yes.
And that includes for your representation of her here today.
So it is actually 3 open matters. So it is your appeal, the one that is still going on and the one that was dismissed.
Right.
It is also your filed modification in Fulton County.
Right.
And this modification. So she has 3 open invoices.
Okay.
However, for today's purposes, I only presented a tailored invoice to today's modification, which I am telling the court that it remains unpaid.
Okay.
And
And if-
actually, and let me back up a minute. I also, because I knew
No,
that.
no, Ms. Cuskey.
No,
I have her on cross-examination, Your Honor. She
Okay,
doesn't get-
wait. No, you have her on cross and she's allowed to, if this is an explanation of a previous answer, I'm going to allow her to do that.
It didn't sound to me like that was an explanation to the answer, the question I just asked. It's something she just thought of.
Well, honestly, at this point, I've forgotten what the question was that your last
Right.
question was. So what was your last question?
I don't have any other questions, Your Honor. I'm ready to make argument on these issues.
Judge, I just like to add one additional light item that we did not bill
So
for.
she may, this is technically a redirect, say, if you will. So go ahead, Ms. Koski.
Your Honor, when we were put on notice that Mr. Jackson's paragraph 7 alleges inability to pay, we had subpoenaed his payroll records from APS, and unlike most attorneys, I didn't double bill. I didn't put a line item in it for the receipt of those documents, which I very well could have because they were in furtherance of this action. And so that has also been discounted for Mrs. Brown.
Okay. All right. Thank you. Ms. McLaws, you may close.
Thank you, Your Honor. Unlike Ms. Koski, I'm not going to take personal shots at her. It's not appropriate. I think you can get the picture. She's represented Mrs. Brown, and she's very, as you saw, unprofessional and inappropriate in her interactions, taking pot shots.
Okay,
I'm
gonna stop now. I'm not saying you're the only one who has been doing it, but we're not going to comment on the other attorneys personally. Okay,
Thank you.
please just speak to me about what you think shows authorizes the court to modify this order and why.
That's correct, Your Honor. As I stated in opening, I will refer you to this case, Mandat versus Lovell, MANDT versus LOVELL, 293 Georgia 807. It's a 2013 case. Ms. Koski is incorrect. We do not have to make out a showing of a material and substantial change in circumstances to modify a TPO order. That is not actually correct. If you look at Mandat versus Lowell, the TPO statute allows this court to modify its order. It's always before the court to be able to be modified. Then I want to refer the court to Dowling, DALENBERG versus DALENBERG, 325 Georgia App 833. It's a 2014 case. This case is almost directly on point in this situation. Mr. Jackson has filed a motion to modify. Part of that, Judge, as he's indicated, as the court is aware, Nia's Place is now saying that he cannot have supervised visitation there. That is a material change in circumstances. Whether or not it relates to earrings and they want to argue completely that, oh, it's all his fault, it doesn't really matter, Your Honor, because the change in circumstances is they're saying they will not allow the visitation. And it is in the children's best interest to have a relationship with their father. For this court to not modify this order, as Ms. Koski has indicated, is basically a de facto termination of my client's rights. That's exactly what's going to happen because Nia's Place will not allow him to have visitation. It's a de facto termination. There's been no showing by clear and convincing evidence that my client's rights should be terminated, nor has there been any notice of it. My client, as to 9-15-14 in this Dallenberg case, he has a right to file a motion to modify. In fact, in the Dallenberg case, the non-moving party requested attorney's fees under 9-15-14, arguing the same thing Ms. Koski's arguing, that it's frivolous. And what the court said was, because under Mandat versus Lowell, a party has a right by law to move to modify, it doesn't meet 9-15-14 A or B because you have a legal right to do it. Therefore, 9-15-14 is not appropriate before the court. In that case, in the Dallenberg case, the father had filed a motion to modify. He was law enforcement and or security, and entering into an agreement on the family law, the family violence could potentially have affected his post-certification. So the father had filed a motion. Now the father withdrew that motion, but the parties had reserved the issue of attorney's fees. The trial court in that case awarded attorney's fees about $6,000 and was reversed under 915.14 and under 1913.4a 10. In that case, Dallenberg, the Court of Appeals very specifically says that the purpose of attorney's fees is to, quote, it permits a trial court in furtherance of the goal of bringing about a cessation of the acts of family violence. Just like here in the Dallenberg case, you have not heard any evidence today that acts of family violence have continued. And therefore, attorney's fees are not appropriate, and it would be reversible error if this court were to enter attorney's fees, because those fees are intended to bring about the cessation of family violence, and you've heard nothing about that today. What you have heard is, interestingly enough, Nia's Place said these children are bonded with their father. They love their father. It is not in their best interest not to be able to see him. It's interesting that they say, well, we're okay with supervised visitation, but we want you to deny the motion, knowing full well that by denying the motion, he will not see his children until the day this order expires. And then the very next day, he will start resuming visitation, but that's not until October, Your Honor. These children, the change in circumstances, in addition to the Nia's Place situation, is these children are now in therapy. You heard Ms. Brown acknowledge that, and that she gave the therapist the TPO order. My client's testimony was that because of that, he cannot exercise and has been denied the opportunity to exercise his legal rights to participate in therapy with those children. You heard Ms. Brown admit on cross-examination, she gave the school a copy of the TPO order that has, as my client has testified, impacted his ability to exercise his legal rights and get information related to the children. He specifically told you these things are occurring and that it is an impact. More importantly, he also told you, and as you heard, limited, that there is a contempt hearing that will be heard next month, that it is a pattern of alienation. The long and short of it is, Mrs. Brown does not want my client to have a relationship with her children. On appeal, it has been fully briefed, and the Court of Appeals will address the grandmother's petition. As I indicated to the court, that is pending and that is correct. And additionally, Your Honor, in order to be able to address the court today, my client could not continue appealing this court's decision today, because it's interesting, Ms. Koski makes certain comments, but at the family court case in Fulton County, the argument was, well, if it's on appeal, then the court doesn't have jurisdiction to hear things. So it's one or the other. We are asking you to modify it to be unsupervised. If the court's not inclined to do that, and the court's indicating you'll take it under advisement, if you will give me until tomorrow to email the court some proposed supervisors, I would appreciate the court's indulgence on that. So we are asking you to modify it. I believe that the court has to deny the attorney's fees, and if not, I believe it's reversible error. Thank you.
All right, thank you. I will take this under advisement. The court, I'll tell you that I'm not going to do unsupervised. That would essentially negate the entire order based on respondents' conduct in making the change in situation, which would be rewarding, which could be something that could be seen as a violation of the court order and not complying with Nia's Place. Nia's Place, when the court orders these, especially in the temporary intervention family violence situation, is a place, a first step to see if all the parties can cooperate for the best interest of the children. and do everything. If the courts see that they can, then they might be willing to move on to unsupervised or supervised exchange. So I have some concern here. There's rules in place for a reason in these situations at this location. And so I'm not going to do unsupervised. I don't think this is a situation of the respondent's creation. What I will do is take it under advisement otherwise. Losing the free option ties the court's hands significantly in these TPOs. If you come up with one that you believe that is a suit, now it can't be a third party because that would really need to be consented to by anyone, and I'm not going in that direction on this case. I mean, the family court case sounds like there's a hearing next month. So, and obviously in this order, it says anything in the family court case, that contradicts this case shall supersede this order. So that's where the long-term things for the best interest of the children need to happen. If you have some supervised visit agencies you wish the court to consider before I rule, you may send those in to the court. Please copy Ms. Koski when you do so.
Yes,
And but otherwise, I will look at everything and take the rest of this under advisement before I make my ruling.
May I have the court's contact information? Of course, I will copy Ms. Koski.
Sure. Ms. Goodman, could you put that in the chat?
Yes, I'll send you a chat.
Thank you very much.
All right, and I will, what's today? Wednesday. I will have to get something, drafted by the end of the day on Friday.
Yes, Your Honor.
Okay. Anything else? Otherwise, the parties may be excused.
Judge,
Thank
don't let
you,
us
Your Honor.
go because we won't get the information from the
Yeah,
chat.
y'all hold on. Just make sure you get the chat. Once you get the address in the chat, you may log off.
Ms.
Stay in